for hosting it as well. Greetings from Massachusetts, which is where we're situated. And when I say we, I didn't hear Ray's introduction, but the we is the Community Environmental Legal Defense Fund. We're a nonprofit law firm that represents community organizations that are doing what we believe some cutting-edge work in the United States around local control and local democracy issues concerning the right to local community self-government. And before I start by explaining what that means and why we're in Ohio next week, because we're visiting Ohio next week in Cleveland, to do an event that Tish O'Dell is pulling together in the Ohio Community Rights Network. I understand Tish is in the room tonight. Tish, where are you? Pick on Tish tonight. So we just got back from the Yukon. People may ask, what does the Yukon have to do with Youngstown and the stuff that's happening in Ohio? It turns out that not only is fracking a big issue in Ohio and in a bunch of other states that we're active in, but also in the Yukon territory, which is just to the east of Alaska, that fracking is a big issue in the Yukon. And there are folks that we met with, both municipal officials as well as indigenous First Nations communities, who want for the first time in the city of Whitehorse in the Yukon to begin working on a community rights ordinance. And in fact, they had a copy of the Youngstown ordinance at the meeting that we attended, in addition to the Moser County, New Mexico ordinance, which was the first county in the United States to ban oil and gas extraction at the county level. That the reason why I bring up the Yukon is that it's a small world. Whether we're in Australia or New Zealand or Canada or Ireland or Italy or the different places where we do international work, it's really been interesting to see some of the local ordinances in the United States pop up in these meetings, because what we think that we're witnessing at this point is really a grassroots revolt of communities who are saying no more. No more to the thousands of different corporate projects that are proposed for their community each year. No more to begging and pleading state regulatory agencies and federal officials to do the right thing. No more about having hope in big environmental organizations to actually step up to the plate to stop what's happening in the United States and elsewhere. Basically turning to each other to say, if things are going to change, they're going to change here, they're going to change now, and they're going to change with the people in this community, the people that we know. And so tonight I just wanted to start with a little background about who we are and what we do and how we got to this point, because we didn't start our work with the Legal Defense Fund taking on some of the world's largest corporations, whether that's Waste Management Company or Monsanto Corporation or Chesapeake Energy. We just got sued, one of our communities just got sued the other day by one of the major oil and gas companies in the United States. We didn't start by taking those folks on frontally. We actually started as a conventional environmental law firm. So back in 1995, we launched the Community Environmental Legal Defense Fund to do something that we thought at the time was quite simple and straightforward, which was to provide free legal services to community-based environmental organizations. And the question we always get asked was, why did you feel the need to provide, set up an organization to provide free legal services to these groups? And the answer is that today, some of my environmental legal peers charge upwards of $1,000 an hour to community organizations who want to appeal a permit, or who have questions about certain local laws, or questions about state laws, or how regulations apply, or any of those things. And they're charging upwards of $1,000 an hour to these community organizations to provide that kind of advice to them. And as people in that room probably know, community organizations have to scrape together just to get photocopies made, or pitch in for gas, or hold public meetings, or those types of things. And the money just doesn't exist for these folks to find a private market attorney to somehow help them out in their communities. And so in 1995, when we launched with a very simple premise, which was we needed to provide more lawyers to the communities who are fighting these different projects. And the projects range anywhere from hazardous waste incinerators to toxic waste dumps to factory hog farms, to fracking, to corporate water withdrawals, You name it, it's what communities across the United States are faced with every day, every week. And what we have is a situation in the environmental law field where environmental law only works for the corporate boys. It only works for those folks that have the wealth to actually animate the system to make it work. When you're a community organization and you're looking at doing something in your community against a particular project, the resources arrayed against you, depending on what the corporation is or what the industrial trade association is or whatever, are immense and enormous. And it's even worse than David and Goliath. It's like tiny, tiny, tiny little David up against a huge Goliath. And so in law school, we were taught that in the United States we have the best environmental laws in the world. In fact, our environmental laws are so good in the United States that we export them out to other countries. We actually have lawyers through USAID and other agencies that go to other countries and attempt to replicate the environmental laws we have here. And so in law school, we had these communities coming to us asking for help in stopping factory farms and toxic waste incinerators and these types of things. And if the problem in the world, if the problem in the United States is not our environmental laws, in other words, if our environmental laws are so good that they're the best on the planet, then the question is, why are things getting so phenomenally bad outside our window? Why is it that 40 years after the major environmental laws were passed in the United States, that by almost every major environmental statistic, things are worse today than they were 40 years ago, right? Why is that? Well, in law school, you're taught that it's not the environmental law's fault, it's the fact that we don't have enough people enforcing the environmental laws. And so we, as the Legal Defense Fund, became one of these unique creatures, a nonprofit law firm that offered free legal services to community groups that were fighting these various projects. And as you can imagine, when you hang out your shingle and it says free legal services to communities that haven't had access to legal help in decades in most places, that eventually you had a line reaching around the block and our phones were ringing off the hook. And so at one point in 1996, we were actually serving as legal counsel to over 300 community organizations across the state of Pennsylvania, which is where the Legal Defense Fund was first born. Those community organizations that retained us to be their lawyers in these fights against the corporate project that was coming into the communities, they would call us to ask us for help, and all the phone calls would generally start the same way, which would be, they would call us up and they would say, Mr. Linzey, we have this 20,000 head hog factory farm that Smithfield Foods Corporation wants to put smack dab in the middle of our community. And they would say to us, our vision of sustainable agriculture doesn't include a Smithfield Foods factory hog farm in the middle of our community, and we want to say no to it. We don't want it here, we want to stop it. To which we, as the learned and environmental lawyers, putting on our lawyer hats, had to explain to them that in the United States, it's well-settled black letter laws, lawyers like to say, that if a state has deemed something to be legal, L-E-G-A-L, like a factory hog farm, for example, which most states actually issue permits to. So if a permit's issued to the corporation who wants to put in a factory farm, that the community itself, the municipality, the place where we all live, the municipal community, is prohibited from banning that use. Okay? So I'll say it again, because we've been going pretty quick here over the last couple minutes, but if the state has deemed something to be a legal use, L-E-G-A-L, has issued a permit, has a regulatory program for it, has the system set up to do that, municipalities, communities, places where we live, are banned from prohibiting that use. Now, that may sound strange, but it's the anchor for how the entire environmental legal, and in fact some of the constitutional legal system operates. So if the state has legalized a use, municipalities are prohibited from banning that use. To which sometimes when I go out and give this talk to different places, people put up their hands and say, well, Mr. Linzey, that's not true. Of course we can ban illegal use in our community. We have zoning ordinances. We have land use ordinances. Well, yeah, we have zoning ordinances, but zoning ordinances are all about separating out incompatible land uses from each other. So residential from industrial, industrial from commercial. If you attempt to use a zoning ordinance to ban a legal use from the municipality, the next thing you're looking at is a lawsuit from the corporation affected by the action of the community in banning the corporation's project from coming in which the corporation sues your municipality for violating the corporation's constitutional rights. Okay? And not only suing for a violation of constitutional rights of the corporation, but also suing your municipality for damages for interfering with the rights of the corporation that wants to bring the project in. Now, that may all sound pretty zany. It may all sound pretty crazy, but that's the way the system operates in the United States. It's because our communities, our municipalities, are treated as creatures of the state. And I don't need to remind anybody there in Ohio about what that means, especially in a state in which the state of Ohio has attempted repeatedly to preempt, and it's passed legislation relatively recently, to preempt municipalities from doing anything in the field of oil and gas regulation or oil and gas extraction. As strange and as crazy as it sounds, the places where we live, whether it's Youngstown, whether it's Broadview Heights, whether it's Oberlin, Yellow Springs, Mansfield, any city, any municipality across the state of Ohio, that people living in those municipalities have no right to prohibit a legal use. So if the state says it's okay, and we're going to legalize it, then the community is banned from prohibiting that use. And so going back to these phone calls that we were having with the community groups that were calling in, they would say, we don't want that factory farm, we don't want that frack job, we don't want the corporate water withdrawal. And they would say, we want to say no to it. We would explain to them very patiently as the environmental lawyers on the phone that unfortunately under the system of law that we have in the United States, you can't prohibit it. Even though we agree with you, we wouldn't want a factory farm in our backyard either next to our property, which devalues property, 2/3 if you live within a quarter of a mile of the factory farm. We wouldn't want it either, but we had to explain to them that the law doesn't allow you to say no. Otherwise, the community can pass a one-paragraph ordinance that says no factory farms in the municipality. But you can't. And the reason why you can't is because when you do, you violate the corporation's right to actually be there. And again, that may seem all strange and zany, but it's what communities run into every day and every week when they try to do something as simple as actually control what happens in their own municipality. So on the phone with these communities that were calling us for free legal help, they would say, we want to stop it. We'd say, hey, we agree with you, but unfortunately the system of law doesn't allow you to do that. And so they would say to us next, the next question was, well, what can we do? And we'd say, we're so happy you asked. Right? Because where you live in Pennsylvania, the state of Pennsylvania has a permitting system. And the state is going to perhaps issue a permit to this facility that's coming in, or maybe already has issued a permit. And what we can do as the environmental lawyers is actually try to appeal that permit to try to get it kicked out, to get the facility to not be permitted. Argue that the permit issued wrongly, that it issued erroneously, that there was something wrong with it, that the state agency should have never have issued it. And the community group would say, that sounds great. What do we do next? And we say, well, just let us take care of it. We'll go in, we'll get the permit, we'll look it over, and we'll decide on a legal strategy. And so that's what we did next. And by the way, this is what environmental lawyers do. This is what we used to spend all of our time doing, is taking permits, sometimes 300, 400-page long permit applications that the corporation has submitted, taking the laws, the regulations that have been written to determine whether the permit issues or not, and then compare the two and find out what's missing from the permit application. And of course, all of this leaves aside, what we don't say, what environmental lawyers don't say often enough, which is the corporations are the ones that wrote the regulations in the first place, right? So they wrote the regulations in the first place. What we're doing is taking their regulations and enforcing their regulations against their permit. That's what we're doing as environmental lawyers. Just to break it down and make it all very simple, right? And so for 10 years, that's what we did. And we got very, very good at it. We would take a permit application, we would compare it to the regulations, and we would decide and figure out whether something was missing. So for example, if a toxic waste incinerator is being built in Pennsylvania, you have to post a $100,000 bond. That's what it was back in the 90s. For the roadway, to protect it from damage from trucks that would come in and out of the facility. And sometimes you'd have a permit application, and they would only post a $50,000 bond, or a $25,000 bond. Or the permit application was required to be signed by the president of the company. but instead the treasurer had signed the permit application, or some other official within the corporation had signed it. Or there needed to be a macroinvertebrate study of the stream that might have been impacted by the project. And we would look at the macroinvertebrate study and, oh, it was 20 years old, so it was never updated. It wasn't recent enough. And we would go in front of the judge, and we would argue to the judge, Your Honor, under section little 2, little c, little d, little Roman numeral 2, little e, little I, little 2, little t, little 2, that there's something missing from the permit application, right? It's not there, right? And the agency acted erroneously. They never should have issued the permit, never should have issued, Your Honor. And most of the times the judge would agree with us. He would say, you're right, the signature is wrong, or the bond is off, or it's printed on the wrong paper, or whatever the issue was that the judge wanted to raise. And he would say, the agency never should have issued it, I'm overturning it, I'm throwing it out. And what would happen next? Well, the community group would go back to their house and they'd have a victory party, right? And at the victory party, you'd have some beer and some wine and some snacks, and everybody would pat themselves in the back and they would say, the system worked, right? The system worked. We had a problem in our community, we got together around a kitchen table, we decided something was wrong, we then found an attorney who could at least put together a complete sentence, we found a good judge, the judge said what we needed him to say, and now we're not going to get that toxic waste incinerator. We're not going to get fracked. We're not going to get factory farmed. We're not going to get drilled. We're not going to get quarried. We're not going to get any of those things, right? Depending on what the permit said. What would happen 30, 60, or 90 days later? Well, the corporation would come back. And this time they'd come back with a new, improved permit application, where they had filled in the gaps, omissions, and deficiencies that we had found on the first round. And they would come back and they would apply for a permit, the agency would issue it, and then the community group would come back to us and they'd say, Mr. Linzey, we want you to do that jujitsu again that you did the first time around to get this thing out, because we still don't want the factory farm. And we would be relegated to saying to them, we're sorry, there's nothing left for us to appeal because the company has now filled in all of those things that we had found, and now we have no leverage anymore. Now, I shortened that down in process timeline, but of course some of us would go through that 10, 15, 20 times because the corporate boys are pretty stupid when it comes to putting in permit applications. And packaging that together with the fact that 90% of permits never get appealed in the United States because communities don't have the funding to actually appeal the permits. And so sometimes just showing up is enough to win on these permit appeals. But you don't win much because after a certain period of time, the corporation comes back. I had attorneys for the Waste Management Corporation. So, some of the biggest companies in the United States come up to me and thank me for finding the gaps, omissions, and deficiencies, which then allowed the corporate lawyers to bill the company more for the hours that they were spending to fill in the blanks on the permit application. That's how ridiculous the whole thing is. It's like running around on a hamster wheel, endless hamster wheel to try to find holes. All the time you're working under a script that the corporations wrote for themselves, yet we think or hope that there's something in those to help us in our community to actually stop these things from coming in. That's the definition of insanity. Attempting to do the same thing over and over again but expecting a different result the next time is the definition of being insane, right? It's what the environmental legal community is all about. It's insanity at this point, right? Because it's not about helping the communities. If anything, it's about enforcing the corporation's own regulations against them. Okay, so what? Well, in front of the permit appeal judges, we had a win-loss record that would make anybody jealous. It was like 135 to 4, because we would go in and we would win these. And we would win them because we were counsel to some of the few permits that were actually getting appealed. What surprised me, two things surprised me at that time. One was a woman named Jane Ann Morris, who has studied she bills herself as a corporate historian, so she looks at corporate history. She said to me two things. Number one, at least I thought we were costing the corporations money. So when we forced the corporations to come in over the permit appeals and they had to spend money on their own lawyers to come in and defend the permit appeals, we thought we were at least costing them money, some pain we were causing them. It was at that point that I learned that the monies that the corporations spend to defend the permit appeals are tax deductible. They're tax deductible as reasonable and necessary business expenses under the law. So we weren't costing them anything when they would come in the door. And the second thing she said to me, which has resonated with me today, even today, is that she said, the only thing that environmental regulations regulate are environmentalists. The only thing that environmental regulations regulate are environmentalists. Because they make us predictable as to how we oppose these projects. The script for our opposition and how we oppose the projects has been pre-written by the very corporations within the industry who have written the regulations in the first place, right? Endless hamster wheel of time spent with that environmental regulatory system, and it's all under the wrong script that someone else wrote for us instead of one that we begin to write for ourselves. The only other thing that happened during that period of time that has stuck with me till today is that, we had a win-loss record of 135-4, whatever the number was, which is impressive. And if you set foot in the communities where we were actually, representing the community, you saw absolutely no resemblance between our win-loss record and the community itself, because the factory farm was getting cited, or the toxic waste incinerator was going in, or the hazardous waste landfill was going in, or the fracking was being done. We weren't stopping anything, even though we had this win-loss record. And the win-loss record, Al Gore invited us to the White House one year. It's one of the 10 best environmental law firms in the country. And I think that surprised us as well, because the liberal community, the liberal progressive community, however we want to couch that, didn't seem to care that our win-loss record didn't really bear any resemblance to what was happening on the ground. They were just there to celebrate people doing environmental law the right way, which I'm assuming was finding gas emissions and efficiency in permit applications. And so we carry that scar with us today, which is that, we don't think any of the political constituencies are really about local control, about communities actually having the end say about what happens within their own municipality. That both liberals and conservatives both distrust community majorities to make the right decisions. And that's a tough thing to grapple with. But I think what we need in the US today is a new constituency that is not embedded in the old ways. One that actually does begin to trust community majorities to do the kind of work that needs to do. So, how do we get there? Well, we practiced environmental law in a conventional way for about 10 years. So from 1995, 1994 to about 2001, 2002. It was at that time in our history that we decided to quit. We decided to close down our office because, frankly, I'd rather work at Kinko's than do environmental permit appeals anymore. It seemed to be more constructive than assisting corporations to build better permit applications, which is what the environmental legal field is today. And it was at that time when we were shutting down that we started getting phone calls from another constituency. And that other constituency that we were not set up to assist was rural municipal governments in south central Pennsylvania, most rural parts of the state of Pennsylvania. And they were calling us, not because they loved us or loved environmental issues, they called us because they were having a problem. And the problem was that agribusiness corporations who had been shot out of South Carolina and North Carolina. People may remember the news from back then in the late 1990s. These big factory hog farms in North Carolina and South Carolina. The hurricane came through, uncapped all the manure lagoons. There were dead pigs floating down the rivers into the ocean, creating a dead zone. The state legislatures in those two states put a moratorium on new factory farms being set up in those states. Those agribusiness corporations decided to move north. They said, okay, we can't set up shop there temporarily in those states anymore, so we're going to come north. They ended up in south central Pennsylvania, and they targeted the south central part of the state for about 400 new factory hog farms. So 400 new industrial-style, vertically integrated, concentrated animal feeding operations targeting into south central Pennsylvania. But they had a problem because a lot of the municipal governments in that part of the state had passed very tough manure management regulations. Basically, leaving aside the specifics about how much liquid hog manure weighs per truckload, which we got into for quite some time, that the fact is that these local laws in South Central Pennsylvania, passed by about 300 municipal governments, 300 things called townships in Pennsylvania, that they attempted to make the disposal of the liquid manure from the factory farms prohibitively expensive by forcing it to be trucked away, with the understanding or hope that if they made it too expensive to deal with the liquid manure, that the factory farms wouldn't site there. It would become too expensive. So what environmentalists have been doing for 40 years now. Instead of coming out frontally, dealing with the situation, trying to go around it by making the regulations so tough that hopefully the corporations will decide to go elsewhere. Well, in Pennsylvania, the corporations decided not to go elsewhere, and they went to the state legislature. And the state legislature, along with the agribusiness corporations, drafted a bill called the Nutrient Management Act. It always sounds so good coming off the lips. The Nutrient Management Act. And what the Nutrient Management Act did was make putting in a factory farm a planning exercise. So all you had to do was file a plan with the state as to how you were going to deal with your liquid manure. And as soon as you did that, then you could put the factory farm in place. At 2 in the morning, which is when the Pennsylvania legislature does their best work, at 2 in the morning, I don't know about Ohio, but it might be the same way, they inserted a preemption provision into the law. And that preemption provision preempted all local ordinances by municipalities that had attempted to make it prohibitively expensive to put liquid manure, to use dispose of liquid manure in those municipalities. In one swoop, went to the legislature passed it, governor signs it, and overnight, these 300 local laws dealing with manure disposal in South Central Pennsylvania were gone, knocked off the books, preempted, nullified, treated as void, given the actions of the state legislature. The municipal officials in South Central Pennsylvania were stuck in a vice. On one side, they had their residents who were freaking out, saying, oh my God, we're now unprotected, these factory farms are going to come in. On the other side was their municipal lawyer. They turned to the municipal lawyer and said, what can we do? We need to enforce our law. And the municipal lawyer says, you can't. And the elected officials said, what do you mean we can't? And the solicitor said, well, that's the way it works. The federal preempts the state preempts the local, whatever the state says goes, and now you have absolutely no control over what happens within your own municipality because those factory farms are going to come in. It was at that point that we started getting a different kind of phone call into the office. Before it was the community group saying, we want to say no. And we would say, well, you can't say no, but you're going to appeal the permit and go into that process. We now had people calling who were quite upset about how the system functioned. It wasn't just a factory farm problem anymore. It was a democracy problem at this point. And in fact, I would say that we don't have a fracking problem in the United States, we have a democracy problem in the United States, right? Because we don't have the authority to make decisions about what happens in our own communities. And I don't know about you, but in the places where I grew up, in kindergarten and first grade, we were taught that democracy means something different than that. That democracy actually means community control and majority rule and consent of the governed, and all that good stuff that flies off the lips of politicians around election time, but doesn't seem to have any application whatsoever when something harmful is coming into the community. And so the phone calls we started to get at that point were from local elected officials in the most backwoods places in South Central Pennsylvania. I mean, anybody who spent time in that part of Pennsylvania, South Central part of Pennsylvania, knows it ain't liberal progressive bill down there in that part of the state. And the joke that James Carville made about Pennsylvania, it's got Philadelphia on one side, Pittsburgh on the other, and Mississippi in the middle, is in essence that South Central part of the state. These folks were calling us saying, we don't want these factory farms. And we tried to do the old gig, well, the state's passed this law and it's illegal and you can't ban illegal use. We gave them the whole ticky-tack speech from start to finish, and they said, well, what if we do? What if we do pass an ordinance banning factory farms from our community? And I said, well, what's going to happen is you're going to get sued. And you're going to get sued by the corporation trying to put the factory farm in. And that's what's going to happen, because that's what's happening across the United States. It's how, we've been, what do you do with the meat? You hammer it, you tenderize it. We've been tenderized as a population by a series of punishment and rewards about what we can and can't do within our communities. And so I would say that to the elected official. I said, well, you can't. And he responded to me by asking a one-word question. Why? Why can't we do that? And I said, well, it's because corporations have constitutional rights. And you're violating those constitutional rights by telling them they can't come into your municipality. And the other end of the line, the other end of the phone, they would say, why? Right? And we'd say, well, it goes back to the 1800s, and corporations now in the United States have the same rights as you do, right? Same rights as you or I do under the Constitution. They have free speech rights. You remember Citizens United and corporations striking down campaign finance laws because it violated their free speech rights. They have unreasonable search and seizure rights under the 4th Amendment. They are persons under the 14th Amendment. You name it. The whole gamut, almost, of constitutional rights that are contained within the U.S. Constitution and the Bill of Rights and other amendments belong now to corporations. The courts have said that corporations have a variety of different constitutional rights. One of those constitutional rights is a takings right, that if you take their property, you owe them money for what you've taken. The permit itself that's given to the corporation to put a certain project into the community is viewed as property by the law. The legal system views it as property. So if you ban something from coming in that's been permitted by the state, you automatically owe the corporation for the value of that permit. In other words, something called future lost profits that the corporation would make by virtue of the permit. And again, this may sound all zany or crazy, but it's the law. It's the way the law actually functions. It's the letter of the law. So we would explain this to the elected officials. We would say, well, corporations have rights. Back in the 1800s, the U.S. Supreme Court said corporations have rights, and other courts said we've given corporations rights, including your courts in Ohio. So state courts have also said that corporations are persons. So your state constitution has been interpreted to mean that corporations have certain constitutional rights within the state of Ohio, in addition to the federal constitutional rights, right? And so we would explain all this to the elected officials, and the other end would get really quiet for a couple seconds, and then they would say, why? Why do corporations have constitutional rights? Where did that come from? That sounds crazy to us. How can corporations? That's like your refrigerator having rights, right? A corporation is a piece of property. You own it. A corporation can be bought and sold. It's property. How does property have rights? It's like your refrigerator deciding to sue you one day, right? By corporation for having rights. Why is that? And we'd say, well, it gets a little complicated there because the U.S. constitutional structure in the United States is written on the basis of something called English common law. And English common law was what the British imposed on us as English colonies, was a system of law called English common law. And that system of law recognized that corporations and commerce actually had certain rights. That's where we get it in the U.S. Constitution, because the lawyers that wrote the U.S. Constitution put it there. They took the English common law stuff and they jammed it into the U.S. Constitution. To which the voice on the other end, after a couple of seconds, maybe a minute or so, go by, and they would say, well, why is that? Right? And we'd say, we don't know. God said so. We don't know. But English common law, of course, can be traced all the way back to the colonization and the empire building and replacing systems of law and all that kind of stuff. So, okay, so what does all this have to do with places like Youngstown, for example, right? The question earlier, what does this have to do with places like Wells Township in Fulton County in south central Pennsylvania? Well, it turns out everything. It has everything to do with it. Because by the time you tangle with a corporation in your community, you don't come up against the corporation first. You come up against your structure of law first. You come up against your constitution first. You come up against that framework of law first. And it's been built very carefully over the past 200 to 300 years to keep you from making the decisions that you want to make within your community, while giving the corporation greater rights to make those decisions within your municipality rather than you. Right? So we would explain all this to the folks in south central Pennsylvania. And at the very end of that very long conversation that we had with folks, which eventually turned into our democracy schools, we teach these 2-day trainings for lawyers and municipal officials and community leaders called democracy schools. We've done quite a few in Ohio, and we'll probably do many more. But they're all about understanding how the system of law operates. Because in the United States, very few people understand how the system of law actually operates. They're working under false illusions or myths about how the system actually operates, and then they try to be activists based on that misunderstanding of history and misunderstanding of how the system of law, structure of law actually works. And so, making a long story shorter, which is people in South Central Pennsylvania decided not to hope that their state or federal officials were going to help them anymore. In fact, they were stuck in a situation where their state federal officials were actually helping to screw them by enabling the corporations to come in and do what they were going to do within the municipality. And so we developed for them, we weren't the first, there were laws before we started doing this work in the Midwest, where some states had adopted things called anti-corporate farming laws, which banned corporations from engaging in farming activities within municipalities or within the states where they've been passed. Why is that? Because the problem really isn't factory farms. It's not animal density, it's not all these other things we talk about when we talk about factory farming. It's the fact that we have a corporatization of agriculture in the United States today. Over 300,000 family farmers have been lost over the past 20 years in the United States as a result of this corporatization and centralization of agricultural authority in the United States. And the experts always say, well, we lost 300,000 farmers. It's like we don't know where they are. We're still looking for them. Well, they've been driven out of business. And unfortunately, suicide among farmers several years ago became the #1 cause of non-natural death for farmers in the United States. So this isn't about one production system being supplanted by another. It's actually about livelihoods and culture and rural communities being torn asunder. There's real violence here when systems get corporatized. And so that's what folks were dealing with in South Central PA when we introduced these ordinances called anti-corporate farming laws, which banned corporations from farming. Because if the problem isn't animal density, the problem isn't factory farms, the problem is that a small handful of corporations control almost every aspect of agricultural production today in the United States. 4 corporations control 60% of pork production in the United States. 3 corporations control 80% of chicken production in the United States. 1 corporation controls 60% of cheese production in the United States, Kraft Corporation. So we have this immense concentration of power in agriculture, this centralization, corporatization. If that's the problem, then we need to get corporations out of agriculture, and that's what these folks started to do. So beginning in 2001, you had the first, what I'll call, community rights ordinances emerge in South Central Pennsylvania. They were about exercising the right of local community self-government, which we contend is a federally, constitutionally guaranteed right, a state constitutionally guaranteed right, and now through these ordinances, a locally guaranteed right. That people within their communities have the right to a system of government that both reflects a majority of people living there. In other words, is controlled by a majority. A majority of people within the community can actually make binding legal decisions. And second, that the government actually protects rights that people have within the community. And guess what? Our fundamental document in the United States, the Declaration of Independence, and it's echoed throughout our state constitutions, echoed through parts of the federal constitution, says that we as people within our communities have the right to alter or abolish the system of government if it violates those principles. That those principles are what it requires to be a democratic system. And when certain systems of government begin to not be democratic systems anymore, that people within communities have a right to change their system of government so it comes back into conformity with what systems of government should be. It may come as no surprise that our governments have been corporatized. I worked in the state capitol in Pennsylvania for a number of years. I watched as the bills were written by the agribusiness community and then given to the state legislatures and given to the ag committees to then run through the legislature and get signed by the governor. We don't even write our own legislation anymore, right? And to think that Congress operates any differently, that's the very definition of insanity. And so what started to happen in the early 2000s in central Pennsylvania was people started giving up hope. They started giving up hope that their state legislature was going to do something to help them. They started giving up hope that the federal agencies and federal system of government was going to do anything to help them, and they began to do it themselves. They began passing these laws, which some lawyers, of course, looked at and said, that's unconstitutional and that's illegal. It's the same thing that they said to those 4 African American kids who sat down at the Woolworths counter back in the 1960s. You can't do that. You can't get served at the lunch counter. You're going to get arrested and hauled away. Well, the community said, we don't care anymore because we're not getting anything out of the existing system that we have now. And we need a different system. And how's that different system going to come about? Is it magic? Are beings from Alpha Centauri just going to beam down to the planet and give it to us? Is the Sierra Club going to deliver it to us? Is some charming congressman going to go out and deliver it to us? Is there a state agency all of a sudden it's going to say, hey, we're not doing our job to protect the public, and all of a sudden on a dime turn around and say, we're going to deliver it to you? Well, no, none of them are going to do it, right? Yeah. And these folks in South Central Pennsylvania who became very dear to our hearts, and this is an adult audience, so I'll say it, they just said, fuck it, right? They said, we're going to do it anyway because nobody else is going to do it. And I said to them, you're going to get sued. And the law professors and the lawyers and all the experts are going to come to you and say, you can't do that. You can't do what you're doing, right? Stop it right now. You can't do what you're doing. And they said, we don't care because we can't be hurt any more than we've been hurt, right? We watch as our own government turned against us, right? Work for certain interests over ours. We're done.
Yep.
We are finished. We're done. We're not finished. In less radical terms, we withdraw our consent, right, from the system it is. And sure enough, I said to them, what's the plan, right? Because you're going to get sued, and these people are going, what's the plan? And they said to us, well, if we do it, maybe somebody else will do it. And maybe after that, 2 more places will do it. And after that, maybe 10 more. And after that, maybe 100. And they said, and maybe that's going to force change. It's when somebody stands up and says, enough. We have a corporate government. It's got to change. We need something different. It's not doing its job, right? And I said, I look back now, I said, fat chance. That's going to happen, right? Because everybody's apathetic. And as I was told the other day by a state legislator, we can't propose activism, that people can't tweet, or they can't, put an entry on Facebook, or do any of the social media stuff, that's what we have to play to, and we can't actually engage them as critical thinkers, we actually have to tell them what to do. Well, okay, that's great. That hasn't worked so well up till now. As Dr. Phil would say, how's that working for you? Right? And so in South Central Pennsylvania, what these guys in this little municipality called Wells Township, population 500, did back in 2001, start to spread. It spread to 10 other municipalities in South Central and North Central Pennsylvania. And then we started getting phone calls from folks who were having problems with sewage sludge. I won't get into the details, but sludge produced by public treatment sewage plants is now land applied to farms. It's a program conceived by the major environmental organizations and EPA as a way of getting rid of sludge, which can contain up to 100,000 different toxic contaminants. We've had a dozen kids get sick or die from sludge being applied next to their homes across the United States. Cornell University tracks all of this. They were calling us and saying, look, 3 corporations control 70% of the sludge hauling industry in the United States. And what you're doing with factory farms, can you do with sludge? And we said, sure, let's take a shot at that. And so we drafted an ordinance banning corporations from sludging within these communities. And that went out into Pennsylvania, mostly the rural areas, and it started getting passed. First 10, then 20, then 50, then 60. We're up to 89 municipalities at one point across about 9 counties that had passed this law. And what was fascinating to me is at one point in Pennsylvania, still is true today, that 10% of all rural municipalities had passed our ordinances, which were basically outright frontal confrontation bans of things that the corporations wanted to do to them. Well, what happened next was, for every action, there's an equal and opposite reaction. On the planet, the reaction is often not equal, but quite unequal. And so what happened next was 2 things. Number one, they sued one of our small municipalities. And what was great about the lawsuit, and usually you don't hear people saying, hey, guess what's great about the lawsuit, was that the lawsuit came in the door, and up to that point, we had been trying to talk to these local governments about corporations being persons, that it wasn't enough to ban a certain activity, you actually had to begin challenging the structure of law that gave corporations the rights in the first place to enable them to do what they're doing in the community. And most of the elected officials would just look at me and their eyes would glaze over and they'd say, we have no idea what you're talking about. And in fact, we don't care what you're talking about because we live in a democracy. And because we live in a democracy, we've decided what to do in our municipality. We've adopted a law. We're going to enforce the law. Don't bother us with that corporate rights, corporate personhood stuff, right? So for a number of years, we were going and telling people that they didn't live in a democracy, and people were saying, you're crazy. Of course we live in a democracy. Well, this lawsuit comes in the door against one of our municipalities, and I'm paying it says, we are corporations, we are persons, and your ordinance violates our constitutional rights. All on page 1, first paragraph. That lawsuit came in, the municipal official said, now we understand what you've been telling us about this corporate rights. It's a hammer that gets brought down when the corporate boys want to actually invade into a particular community or stop by some kind of legislative enactment from doing so. And that lawsuit spread like wildfire. You know, it was bashed all over the place, and people got a hold of it, and we started getting asked questions about what a municipality can do about corporate rights. And so we launched in our, legalese, and we said, well, of course, communities can't do anything about corporate rights. The U.S. Supreme Court has said corporations are persons. You can't affect that in municipalities because the federal trumps the state, and the state trumps the local. La. To which the community said, we don't care. Because they said, we're getting sludged anyway, and we're getting factory farms and all these things, and we want our ordinances to be enforceable. And they're not enforceable because corporations have rights that they can use to sue us to try to overturn it. And I said, fine, well, what do you want us to do about it? And they said, well, can you draft an ordinance that strips corporations of certain constitutional rights within our municipality? And we said, sure. And we went back to the office and we drafted the Corporate Rights Elimination Ordinance, which refuses to recognize that corporations have certain constitutional rights and powers within the municipality at the municipal level. And if you think about it, it's not really crazy at all, because what was happening in Pennsylvania was people were beginning to use their noggins. We were treating people as real thinking people, capable of critical thinking, capable of figuring their way out of a problem. And what they were saying was, we don't want sludge. And what the law was telling them was, you're going to get sludged because corporations have certain rights that they can use against you otherwise. And our municipal officials were saying, well, if that's the case, we need to get rid of those corporate rights, right? So it was a logical progression of thinking. So, when you look at the Youngstown charter bill, which is on the ballot this November, the wording doesn't come from nowhere. It comes from 150 other communities who have done the same thing because they've begun to practice. Yeah. They're not just treated as consumers anymore or some other label that's put on them. They're actually citizens. They're residents. They're people who are actually engaging in their lawmaking process because they've done critical thinking about what are we stuck in and how do we get out of it, right? And without that creative, concerted, coordinated thinking, there's no way we're getting out of anything. Right now, what's very clear to those people in Pennsylvania as they started this thing rolling was that they don't decide shit in their community, right? I mean, sure, they can decide how high to allow noxious weeds to grow on their neighbor's property before they're going to force somebody to mow it down, right? They can make those types of decisions. But man, you start to touch on energy, agriculture, transportation, fracking, just to pull an issue out of the air. And you start to deal with those very big ticket items that have been put off limits to our communities for the last 100 years to decide on, because they've been reserved to the corporate boys to make those decisions. You start touching that live wire, and all kinds of stuff starts to happen. And the stuff that starts to happen is wonderful, right? Maybe a lawsuit. In Pennsylvania, it wasn't just a lawsuit coming in the door, it was the legislature. They passed something called ACRE. Oh my God, what a horrible bill that was. ACRE stands for Agriculture, Communities, and Rural Environment. And we've been going very fast here because we had some stuff to get through. But let's pause for a moment, because in Pennsylvania, they passed a law that places the Attorney General's office at the discretion of the agribusiness corporations to sue the municipalities that have passed these ordinances to overturn them in a court of law. So our taxpayer monies being paid to the Attorney General's office, to support the Attorney General's public official. All the corporations have to do is pick up the phone and call the Attorney General's office. They will assign an assistant Attorney General to the corporation, and then the assistant Attorney General comes into your community to tell you that if you don't repeal the ordinance that you've adopted, because it's illegal and unconstitutional and everything else, that it's not the corporation that will sue you. It's the state. It's the Commonwealth of Pennsylvania that will sue you, right? Which, to tell you the truth, was wonderful to us because we kept telling people in the interim, hey, it's not the corporation that's the problem. It's your own state that's the problem. It's your own government that's the problem. Because the corporation can't do what it does without being enabled by your government. Corporate rights come from your government. Preemption comes from your legislature. It's your government, right? That's the problem. It's not just the corporation. But boy, nobody listened to us on that either. Until the Attorney General's office started appearing in the communities on behalf of the corporations, right? It was wonderful. And we had this situation in a little place called Schwebel County, Pennsylvania, right above Philadelphia. Assistant Attorney General shows up, and generally the way that they do this is that they try to have a private meeting with the municipal officials. Well, the community group in that particular municipality did a sit-in to stop the Attorney General's office from meeting with the municipal officials. The Attorney General then had to do a public presentation to the elected officials. And at the end of that, the women, mostly women in this community group, as with many of the groups out there, physically escorted the Assistant Attorney General out of the office building and told him to go back to Harrisburg because they didn't need it anymore. There was a Harrisburg Capital newspaper reporter there with a photographer. Took a picture of the Assistant Attorney General being led out of the municipal building by the women in the community group. And that picture appeared on the front page of the Capital newspaper the next day. What happened then? Well, the state of Pennsylvania sued the community. The Commonwealth of Pennsylvania versus the municipality. So not the corporation, but the state itself. You know? What happened next? A municipality next door passed an ordinance suspending the authority of the Attorney General to enforce an anti-democratic And so things have started to get interesting in Pennsylvania over the past 5, 6, 10 years now. Where about 110 municipalities have passed these types of laws within the state of Pennsylvania. In addition to that, the laws have expanded outside of PA. The first place where they expanded was New Hampshire. In New Hampshire, Nestle Corporation and a company called USA Springs, they come into communities, they siphon water out of those communities from the aquifer. Nestle to bottle and sell overseas in Italy was the plan. So you have New Hampshire communities that began to stood up about stopping Nestle and these other corporations from taking their water. They began to pass anti-corporate withdrawal ordinances within the state of New Hampshire. And then the laws began to migrate further into Maine, where they're dealing with a variety of issues, including corporate water withdrawal as well. They have, of course, migrated into Ohio, whether it be Yellow Springs, Mansfield, Broadview Heights, Oberlin. This year, of course, the Youngstown Charter Amendment is on the ballot again, in addition to Athens, Gates Mills, and Kent. I mean, basically what you're looking at is a community revolt in Ohio that is at its beginning stages, incipient stages, as it was in Pennsylvania. It has migrated to Colorado, where the Colorado folks have put up a first state constitutional amendment to take power away from the state and return the power to local communities to begin not only passing ordinances to ban fracking and oil and gas extraction, but also to define corporate rights and powers within their municipalities. So a state-level constitutional amendment that seeks to control power back to the people in those communities. In Washington State, we worked with the city of Spokane and people within the city of Spokane, 25 different organizations, to put together a community bill of rights with the city of Spokane. The first time it ran, and the Community Bill of Rights had 4 rights in it. Some of the rights language is similar to that in the Youngstown Charter Amendment. But the first right was neighborhoods having the authority to veto Walmart. So the authority to stop big box stores within their neighborhood from coming in. The second one was about labor rights. Unbeknownst to many people, when you work in a private workplace in the United States, you lose your constitutional rights when you cross the doors, when you cross the threshold into the workplace. You have no First Amendment or Fourth Amendment rights at work. And so those rights are sliced from you. So this was an attempt to reinstate those. In addition, they had a rights of nature provision to protect the Spokane River and the aquifer within the city of Spokane, and then a final provision that stripped or refused to recognize corporate constitutional rights within the city of Spokane. First time they ran it, which was back in 2009, they put it at the polls and it got crushed, 75 to 25, in a way that most people just go home and start crying and never return to political life again. The Spokane folks, however, expected it to be a multi-year battle, which I think is what Youngstown, of course, has shaped them into. A multi-year, multi-political season, multi-election season battle in which they re-qualified the Bill of Rights. They came back and it lost by 0.5% in a city of 200,000 people, 0.5%. And then in 2013, they came back just like the Youngstown folks and said, we're going to do this again, because we're not going to get stopped by the corporations who've been putting money up against it. And they did it again, and this time the Chamber of Commerce and the corporations affected by the Community Bill of Rights sued to keep it off the ballot, because they knew it would pass. And so they sued to keep it off the ballot. And they won the trial court level, just had an appellate hearing trying to get it back on the ballot. But that's what these guys do. That's what they do for a living. They are resourced to do it, to try to stop us. And so one time's not enough. Sometimes twice is not enough. 3 times is not enough. 4 times might be enough. There is no stopping, because once we stop, we're essentially admitting the fact that we have no power whatsoever in the system. So it's got to keep going.
Yes.
And then to us, the amazing thing to us was that 8 states in the U.S. have now passed ordinances along the rights of community rights ordinances. What do they contain? Well, all the same stuff that the Youngstown Charter Amendment and the Broadview Heights Charter Amendment contains, which is, hey, we have a right to a local community self-government here. We also have a right to clean air and clean water and a sustainable energy future. And we have the right to ban activities within our community that actually violate our rights. What a novel concept. We have these rights. We can't let activities come into the municipality. They're going to violate those rights. So we have to ban those projects and those activities from coming into the municipality. And then to protect the ordinance, we have other layers built in. Refusing to recognize corporate rights. Refusing to recognize state preemption, so that any permit issued by the state is deemed to be null and void within the community because it automatically violates the Community Bill of Rights. So all these layers of protective mechanisms, because after all, if we know that they're going to come at us in certain ways, we need to embed in these legislative enactments the defenses that we need to actually begin to litigate these cases in a way that talks about the right of local community self-government. And then to add the final, the icing on the cake, is we started getting calls from other countries. So, Northern Ireland and Italy and England and groups in Canada and Australia and New Zealand, different places that are reading about what you're doing, what folks in the United States are doing, and have begun to start doing it themselves, because guess what? In Australia, they have an English system of law that's almost exactly identical to ours. In Canada, they have an English system of law. It's almost identically similar to ours. It's all about centralization. We were in Australia. Western Australia is about to get the shit fracked out of it. If you look at a map of Western Australia, it is lit up like a measles map. It's got red dots all over it, because they're going to frack it into eternity unless communities start standing up to say no. And that's what we were there to talk to them about, was how do we stand up within Australia, just like communities in the United States are beginning to stand up. So, I'm running out of time here, but I want to finish with a couple thoughts. The first one is this. People ask us, where is all this headed, right? And first of all, they ask that question, rarely have any idea. I mean, people ask the abolitionists in the 1840s, where are you headed? They would say, we don't have a clue, but we know what's morally and ethically right, we need to get there. In the United States, what's happening now is that you have a critical mass of communities in 8 different states that have either passed ordinances or begun to qualify those local laws onto the ballot. Those 8 states and communities within those 8 states have formed state community rights networks, so CRNs. And those CRNs have come together in those 8 states to begin to working on state-level change. So in other words, how to harness that work that's happening at the municipal level with people who finally come to grips with their understanding that we don't live in a democracy, we live in something else, and how do we actually create that democratic system? So now those CRNs, and Colorado was one of the leaders in terms of proposing the first state constitutional amendment to change how the system actually operates, to change the rules. So in the regulatory stuff, of course, we work under their rules. It's about actually writing our own rules, something that used to not be so foreign to Americans. thinking back to the American Revolution and the people's movements that we saw across the ages in the United States. So that's state-level change. In Ohio, the Ohio Community Rights Network has formed and issued a declaration, a belief statement, about what they believe and what direction they're moving, and are working to propose state-level change that would actually return power and decision-making authority to local communities. So in about a week, it's only a week and a half away, that delegates from each of these state CRNs are gathering in Pennsylvania to talk about what federal constitutional changes are necessary. Because while there's a lot of stuff that needs to be changed in the state framework, there's a lot of stuff in the federal framework that needs to be changed as well, including things like corporate constitutional rights at the federal level that need to be changed. So that's the pathway, that's the riverbed, but it needs to be populated, people need to come forward, people need to lose their activism where they talk about things like, well, we just want a voice at the table. Doesn't it kill you when you hear people that say we just want a voice at the table? It's all we want is just a voice at the table. Well, what I always say to them is, we own the fucking table. We decide who gets a beverage, and who gets utensils, and whether there's food served or not, or whether somebody can sit there or not. That's our decision to make. And that's just not me saying it, it's not our community saying it. Track it all the way back to the Mayflower. There's nothing more American than the Mayflower. You know, people came over and they put a political document together that said, we govern ourselves. And when the system doesn't work anymore, we have the power to get rid of it and replace it with something else. So all through American history, leading up to the American Revolution, in fact, it was the reason for the American Revolution, about self-governance. That's what this movement is about. This community rights stuff, that's what it's about. We're to a point where we don't think there's really anything else to do, because we can try to influence. You know, our entire activist lives have been about influencing elected officials. I'm tired of trying to influence elected officials. It doesn't work. And even when it does work, then the corporate boys come in and kill whatever you've done in terms of influence in the first place. I'm tired of marches. I mean, marches are always good. You get to know good people. But I'm tired of marches. When are we going to use marches to actually support real, concrete stuff in communities? I'm tired of holding signs. I've done that. I'm tired of appealing permits. It's not just me. It's other people that we're working with now. We're tired of doing stuff that doesn't work, right? It's time to start doing stuff that works. And instead of asking ourselves, what can we get under the existing system of law? Because that's what conventional activism is all about. We get together around the table and say, what can we get within the existing system? We need to actually start asking, what do we want and what do we need? And then actually seizing our municipal governments to make it so. That's what we have to do, because nothing less than that is actually going to change the precipice that we're on. People talk about we're running out of time. We're not running out of time. We're out of time. Mm-hmm. It's gone, right? Because the elected officials and the structure that has been screwing around for so many years. It's done. It's gone. And, you know, the last thing for me tonight, because I know I'm running out of time, is that one of my favorite authors is Derek Jensen. People on the East Coast don't keenly know who Derek is. He's a Pacific Northwest author. He's written a lot of books about the state of environmental activism or lack thereof in this country and what needs to happen. He talks about the need to give up hope, right? Because hope is about hoping that someone else is going to intervene to save us. And he uses this great statement, you know, that beings from Alpha Centauri, which I borrowed earlier, the Sierra Club, or some congressman's going to jump in and save us. Hope is about giving up hope that anybody else is going to do it for us and that we need to do it ourselves, because it's the only thing that's going to happen. We've stripped ourselves of agency. We don't see ourselves as players anymore. We don't see ourselves as the decision makers anymore. Instead, we turn to that influencing model. And as Derek said in one of his recent books, you know, it's like pretending that we're going to compost to stop Hitler. That, you know, personal change is good, and changing light bulbs, all good stuff, buying Priuses, but it ain't going to get us out of the situation that we're in, which is way, way too deep for that kind of change to affect. We actually have to begin to seize our governments to make that change. Thank you.
God bless. Thank you.